My lord, I beg to mention item number 52. I beg instruction to withdraw the petition for
Item
52, Lordship, supplementary admission.
Please
Legal liberty
supplement.
to file a press for.
Okay. The K. Majumdar Learned Counsel submitted. He has instruction to withdraw the petition. Accordingly, this petition is dismissed on withdrawal.
My lord, liberty may.
Okay.
I know. Part of
Earlier
the
also not after that. First not at 2 months. I thought not.
Okay, that matter.
Yes, sir. Yes,
That that we have training.
yes,
Dilip Majumdar's name is
yes, yes. I
Mr. Majumdar. So far relating to the other case, that our documents was that with Gayon. Document was not in the other case. Document was brought on by an additional affidavit.
Yes.
Here, please give a copy of that so that we can record it.
Yes.
That has been produced and kept as a part of it.
Right.
Okay. We have passed the order like that, so we need a copy.
I'll do. Right. Okay.
Ready?
Wait, wait. What the second?
Huh.
Now 45.
Mark sir.
May it please, Honor. Lord, with the consent of our learned friend, my lord, I beg to mention item number 3, my lord. This case, my lord, I am led by Senior Counsel Mr. Sharma. He is not well. It will for passport for
What is
the
the issue?
This is, my lord, a non-payment of my lord, salary.
Non-payment of salary of what?
This, my lord, earlier they were employee of the state post council.
Now,
Post council was merged with my lord post authority of Assam.
then
Yes, post authority of Assam, they have, my lord, a research society, my lord.
Mm.
They have own guidelines and, my lord, rules.
Mm.
But accordingly, rules, my lord, they have to sign in, my lord, and contract agreement.
Mm.
Their services are, my lord, only contractual.
Mm.
But they refuse to sign that contract, my lord. In fact, my lord, two of the petitioners, my lord, they did not join after murder of the sports council. That the issue to be,
yes,
my lord.
Mr. Day. No, that consent may not have effect upon us.
Right.
Because it's 2016.
For a day only, my.
You did not take a consent from this court yesterday.
Yesterday, my lord, they.
Isn't it? So consent
My
is
lord,
now a
I
discussion.
apologize, my lord. For a day only.
Yeah. Anything? Any rate of indamas can be achieved?
Because they were otherwise regular employees of the state. That's not.
Okay.
That's not.
Who will pay the salary as of what is the period of salary?
Not since 2018, we are not getting it.
Okay. If you have given a consent, what can we do?
Make the rod apply. Because I
Done.
put 8 rod.
Yes.
I instruct.
On just a minute.
Yes.
Item number 3. On behalf of respondent number, we have a prayer for example.
Deeply obliged.
Not objected by the petitioner according after which
8 rod. Regard to I 8.
the A does not council for the petitioner submitted case. Yeah. Any liberty? No liberty. What liberty?
Apply zero. Maybe the law.
Yes.
I took the pay.
Huh?
After the flag.
What instruction of that? Huh? Huh? Wait. You want to withdraw? Okay. Item 11. What is your name? AK Das on behalf of, your name is there? AK Das on behalf of SC.
May I please, my lord. My lord, I am praying for adjournment of item number 23 with the consent of the other. Can it be listed after 3 weeks, my lord? We are yet to obtain instruction and to file our affidavit.
3 weeks. The prayer of
K. Vishwakarma on behalf of Mr. S.P.
SC. Not objected by the petitioner. For affidavit. For petitioner. Learned counsel for the respondent prays for any granted 3 weeks time to file affidavit.
I oblige.
As this matter is pending since 2018. Let the affidavit be filed by by the next week if to advise. Otherwise, this court may take up this matter on the basis of available material available.
Problem.
Pass out the date.
Item
Because here is the profile. From last 10.
the prayer of the learned council for the petitioner, matter can change on and be listed after 3 weeks.
Sir, item 34, madam. In here.
Ah.
But here, the applicant city was called for that. I've been from that.
So, learned petitioner public prosecutor submitted that he may be granted 2 weeks time. One. Any interim? 3 weeks time.
No interview, my lord. It was earlier rejected.
3 weeks time to file to produce the up to date date. Prayers can allow, please this matter on. Make it 2 weeks.
Fine.
Date. Bail date. 22nd of. Get you. Bail.
Bail.
18th.
Kingdom.
Learned counsel for the petitioner, press for and granted, and press for an adjournment. Prayers can allow. Please after 3 weeks.
I beg to mention item.
Yes.
With consent of other side of it. Matter may be candidate near.
It is your lordship in item number 44. Yesterday, I have filed the affidavit in opposition. May it come today.
Item
44.
who file affidavit?
Miss B. took it.
No, for
Following the-
respondent.
Opposite party
Okay.
in cotton.
25. Why you need an adjournment? Petition of 3 weeks.
May please accept it. I take my. With the consent, we are. Okay. 28.
Petitioner. Yes.
Hey, please, the Lord, take to it is for listing.
Not this court. Go to the court number. If it is. Item number. Why? You are for? Wait. We'll accommodate. Wait for.
Yes, we don't take case matter, item number is 8.
Yes.
So my name is. As matter. Ekhoni kor. Respond number 2. Deep level.
47. Airport accommodation. Will be going out.
Yes, respondent have taken consent from the
Yes, yes,
respondent,
yes. No problem.
but it's by, it was listed on mention.
Yes.
On whose behalf?
Yes.
47 and 48. What about 48, 7? With 45. No. 47 is different. Okay, adjourn.
I'll leave.
47 and 48.
Airport 36.
2 weeks. 2 weeks or 3 weeks, whatever. You will not fix it. You make a mention, you get it listed. So the entire process involves physical work, practical physical work by the registrar. It's not a happiness that you will make a mention at your wish. Matter will be listed. You will get adjourned and you will seek a date.
petitioner ultimately he was promoted to the post of senior assistant. His delegation is junior were promoted before him. And as per my
That's why he has not taken steps.
yes, he has got relief. And ultimately, while we have received the instruction that petitioner did not participate in the departmental proceeding. Departmental departmental promotion committee for promotion to the post of senior.
Okay, we'll wait for some time. Call later after admission letter. Time to file on the prayer of the learned counsel for the petitioner. Time to file affidavit in reply to the affidavit in opposition filed by the respondent was granted by this court on 19/6/2019. No such reply affidavit has been filed. Accordingly, let this matter be listed in the admission. Yes. That is the item. Let the matter be placed, not admitted. Let the matter be placed before the Lawajima court as regards determination of completion of service in respect of respondent number 5, 6, and 7. The present application is filed alleging willful and deliberate violation of this court order dated 35/2018 passed by this court in WPC 5324 of 2016. Full stop. By the aforesaid order, the claim of the petitioner for grant of pension as per Assam Pension Service Rules 1969 was directed to be decided by the Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department within 1 month from 23/5/2018. On 16/10/2023, the learned counsel for the petitioner, Ms. N. Saikia, sought for time to file appropriate application for arraying the present incumbent as party response. However, no affidavit has been filed till date. Anybody from health? I have a copy of this order. And just open it. This court, in the appropriate backdrop, this court has requested MS
Keyboard.
E. Bora, Garden, sending conflict for the Health and Family Welfare Department to obtain an instruction whether the appropriate order in the meantime being complied with. And if not, the reason here. MS E. Bora has readily accepted the request, readily accepted the accordingly, release this matter on. I think this has been complied. 1st of March 2024. Let me give a copy download. Just give the order. A copy of the order dated. Registry to list this method showing name of MSP Bora Learned Telecom. Give a down. Nothing is there. She claims that I am entitled for pension
Yes.
under new old pension scheme. She was granted under the new pension scheme. Court says, okay, you decide. That's all.
I-
No discussion on merit. Yes, next. Or hard or hard or
Captain is not, is out of state.
none appears for the petitioner on call. None did represent the petitioner on call when the matter was listed on 16/10/2020 and 31/7/2020. In the view of the matter, this court requested Mr. R. Learned Additional Senior Government to apprise this court regarding compliance of the direction contained in order dated 22/7/2019, passed in WPC 8164/2008. It's submitted that Mr. Thor is out of session today. Accordingly, matter stands adjourned and released after
2 weeks.
2 weeks.
Thought that is complied. In fact, Lordship, SLC rejected the case, reconsidered the case of the petitioner,
Hmm.
and he has preferred another his petition. Now,
Okay. This contempt petition is filed alleging non-compliance with an order dated 15/5/2019, passed in WP 2793/2018. By the aforesaid order, the respondent SLC was directed to consider the case of the petitioner for compassionate appointment appraised. It submitted that DLC has already considered,
SLC has considered
SLC
the
already has considered the case
6/8/2020.
in its meeting held on
6/8/2020.
6/8/2023 at 20, and the claim of the petitioner has been negated by the SLC. Stop. It is also submitted by Mr. Upadhyay, Learned Counsel representing the contemner, that in the meantime, the petitioner has filed a
Filed
fresh-
another petition, Lordship.
filed another writ petition saying such
number of-
rejection order
being number 5263/2020.
2020. In view of the aforesaid, the contempt petition that's
Obliged.
and open. Yes, Pujari, what is this?
My lord, this is the case of my lord granting of ex gratia.
Hmm.
That an appeal has been before the Honorable Division Bench,
Hmm.
and that appeal is still pending. That appeal has been, my lord, admitted, and my lord, the impugned judgment and order has already been paid. But the last occasion, this Honorable Court took a query to me, my lord, to praise the last latest order.
Hmm.
It was last listed on 18/1.
Tell us, just tell us.
There appears to be a change in counsel for the writ petitioner, my lord.
Hmm.
But they did not appear. Thereafter, my lord, it is not listed.
Okay,
It will be pleased to adjourn the matter for further 4 weeks.
it is submitted by Mr. R. Borpujari, Learned Counsel for the petitioner. The order alleged, order dated,
It is ordered it is,
uh,
my lord.
20
Sorry.
judgment and order dated
That, my lord,
28/3/2019,
yes, my lord. 28/3/2019,
28/3/2019,
passed in
which
WP
is
criminal.
passed in WPC
WP criminal, my lord. Criminal,
criminal 3 of 2017.
my lord. That has been
Uh,
still before the honorable.
Just a minute, certain, which is alleged to have been violated
Right.
by the respondent, comma, has already been stayed by the division bench
Right.
in writ appeal number
138 of 2022.
148 of 2020,
138.
Hmm?
138.
138 of 2022. Full stop. Though a request for PC was made by the learned counsel for the petitioner, however, then when request, though a written request was made for partial hearing by the learned counsel for the petitioner, however, no request on no online request which is necessary to provide a link has been made till now. In view of the aforesaid, let this matter be adjourned for 4 weeks. In the meantime, the learned counsel may apprise its court regarding the outcome of the.
I'm so obliged.
Yes,
Copy of the order, your website has been interpreted for improvement of those present in country. That was not them.
I doubt Supreme Court has interfered with order.
It is pending.
Just verify it. Might be learned counsel for the petitioner press for and is granted 3 weeks time to file necessary. Where is that? Okay, which learned counsel for the petitioner submits that though he has filed necessary application for the implement of present incumbent who are responsible for implementation of this court order dated 6/2019, passed in WPC 4238 of 2019. However, already filed appeal. File. Let this method be listed. You will have to make a mention accordingly this method. You cannot pass an order here to list them.
Hello.
None appears for the petitioner on call. Why these respondents are not here? The contempt to be called for personal appears for absence of the lawyers. What is this? Call Mr. Saliha. Yes, if- and A. Fukan. For Prabhakar. Yes, why you want an adjournment?
Right.
Contempt in between us and the contemptor. Your personal difficulty will not come in between. Is it not? Huh? Until and unless it is a case of dismissal. Where is the order? Yes. Who is for director of craftsmen? Anybody appear? Let him be personally present. Who appears for this Mr. Generally represent? If lawyers are not responsible, let the client be present and explain. Is that it? Uh, the present petition is filed alleging willful and deliberate violation of this court's order dated 22/4/2021, passed in WPC 289 of 2000. By the aforesaid order, no, in the aforesaid writ petition, the petitioner claimed for promotion to the next higher grade. This court uh, without determining the entitlement of the petitioner regarding the promotion to the next higher court grade, directed to consider the case of the petitioner not without delay. This court has directed to consider the case of the petitioner in terms of the determination made in paragraph 11 of the judgment within a period of 4 months from the date of receipt of a certified copy of the aforesaid order. Subject to the condition that the petitioner come within the zone of consideration. An affidavit in opposition has been filed by the sole respondent explaining that a request was made to the Director of Employment and Craftsman Training from the sole respondent requested the Director of Employment and Craftsman Training to do the needful for compliance of the order, as the said respondent in the meantime has retired, and according to her, she could not comply with the order due to some technical difficulty. Nothing is discernible hereafter, whether the case of the petitioner is considered or not. Have you got to the notice of the new incumbent? No. That's why they are not here. In the aforesaid backdrop, the learned counsel for the petitioner praised for and granted to do the needful to intimate the present incumbent regarding non-compliance of this order, and in the event of failure to comply with such order, to file appropriate application for it. Please stop that.
Better I was directed to obtain instruction from the Chief Secretary, my lord, regarding some anomalies is there.
uh.
Now, we have said 2 letters, sir. Let me,
Silent affidavit.
let me
Okay.
have a last chance, my lord. Over telephone, I would talk. Okay, my lord.
Okay. We want a clarification.
Yes,
That's
yes.
all.
No, is it a good gesture you also wanted to
Yes,
clarify?
because many cases there is
we
no
want-
standard. There must be a parameter in every case.
Yes, yes. We want
In
to
some cases, some clerk will give a file above. Isn't it?
Yes.
His case will be taken first. Somebody will go to the town if the case is also earlier. No, nothing on that regard. Every meeting, somebody's cases will be taken up, somebody is not.
not
We want to know what should be the parameter.
yes. Sometimes we will give them, my lord.
If we dismiss this kind of petition on the ground of delay, then we want to fix the responsibility. To fix the responsibility, maybe the clerk, may we direct that you can recover it
Maybe,
from
yes.
the salary.
Maybe, my lord.
So why not?
Yes. And DLC also,
Please,
they are
there
not.
cannot be any whims and fancies.
Yes, yes. The clause
Yeah,
is-
learned counsel prays for further 2 weeks time to file affidavit. Full stop. Prayer is allowed, however, this court expects that the affidavit be filed by the next day 6. Make next day 6. As already as adjournment has been granted earlier. list it on your date. 13th of this. Apply.
Keep your.
Not there.
Hmm.
The petitioner who was was tracking the contractual loan.
Hmm.
What is it come? What is it still come? Data center in the Bomayon district.
Hmm.
The big what is it committee.
Hmm.
Thereafter, he has got how he did the order. They have to get for going any further.
Whether these things are there,
Yes,
I don't know.
other employees are other
You are still working. What happened there?
they have the application.
There was an interim order. Then what happened there?
After
another experience. But here, subsequently, initially we took a notice, but here soil conservation department is the main party, or all the parties except for the last response.
Now there is standing council.
RS Deori, if I'm not wrong. Soil
Uh, it is submitted by Mr. Hajarika, CS
CS,
Hajarika, learned petitioner,
junior government.
learned junior government advocate, that 2 notices were accepted by the government council. However, in the meantime, the soil conservation
Soil conservation.
Soil Conservation Department has engaged engaged standing counsel for their department. In view of such submission, matter stands adjourned and be listed on listed on 6th of March, showing name of the standing council, soil conservation. The petitioner may also obtain instructions and apprise this court regarding the present status of the apprise this court regarding the status of engagement, status of contractual engagement of the petitioner as on date. You obtain instruction whether he is still there, because there is an interim order. Interim order will necessarily mean that contract period. If that contract is over, no first phase contract is executed, nothing survives. This will become infected.
if you
Yes,
it
Mr.
will take some time to file a if it in reply to the affidavit filed by the whether the petitioner will be covered by the new pension rules or by the old pension rules. That is the controversial. According to us, actually will be covered by the old pension rules, not by the new pension rules. So they were appointed long before the new pension rule came into force.
Okay, you need to file a reply, but its matter is of 2017.
We are trying to contact our client also, but we have failed, man. Even that I will try, man.
May I plead your lordship? And for PNRD, your lordship, extra copy has not been submitted.
What extra copies now? Are you sure?
Yes.
We'll verify whether or not. How can you file an affidavit in opposition?
At that time, lordship, we were not.
We have had
Who filed?
pension and
What is your stand?
This is a response number 3 has 5 piece exhibit. Only they says on the paragraph 4,
Mm.
that is fact that the Pension and Public Grievances Department filed endorsement dated 21/1/2014 in Panchayat and Rural Development Department file number 20.
These are employees under DRDA.
Yes.
Originally, but originally.
It is a
And then when the
is
DRDA was,
passed to the Jilla Parishad.
where was the amalgamation order that they will be absorbed? That is a vital issue.
Merger in
No, they have
2014.
they have been now आता
Now,
जिल्हा परिषद आणि आंचलिक पंचायतीमध्ये
understand,
Public and Pension and Public Grievances Department Bharat endorsed.
your stand is that, see, yours, I think from your document, your stand is that they were absorbed in post created on 31/8/2016. So if posts are created on 31/6/2013, they become into the government fold because earlier to them they were under DRDH scheme
Right.
sponsored by central government, something like that.
Yes.
Central government. So therefore they cannot be treated as a entering into government service. On 31st August 2016, posts were created personnel to them till they are superannuated. So their case is that therefore you will not be entitled for pension under those scheme. Apparently they are correct until and unless you can say something
No,
different.
but for the I require for some type to file a reply. But
I do not think you require a reply. It should be a question of law.
well,
There is no dispute as this
Okay.
regard. So therefore you need an interpretation. What should mean an entry into the service.
Right.
That's all. The Anti-Trust Garnet Senior Counsel submits that it may be granted a little accommodation to argue this matter.
Right.
Full stop. Prayer is allowed. Prayer is allowed.
because if the whole method, this will be the next week method.
Next week may not be possible.
I give it to you, Lord.
But whenever possible. It may take some time, not too much of time, but 11th of March.
I'll let you.
That's
Give
what,
a copy to the PNRD. Okay.
that's what 3 and 4 has filed.
Respondent number 3 and 4 has
Don't
in
have
the meantime
validity.
filed affidavit. Give a copy to, otherwise it will get action. Yes.
It is a hearing. I was appointed as our divisional LTA,
Appointed as.
LTA,
Hmm.
Kulimbo District Regular Marketing Force.
Hmm.
The year 2000. Called one Midal Solpa, who is Mayor, the petition as far as professional capacity, was appointed to the post of marketing from LTA.
Hmm.
Order of the Honorable Read petition, that is, read petition number 2921 of 2007, at page
Hmm. Page
56.
anything survive?
After that, at this step, I will also consider putting my event.
Hmm.
At this step,
Because you don't have any connection with your client. Isn't it?
yes, I have connect.
You have.
Yeah.
So still he is aspiring for promotion. Heard, Mr.
He could
E. Kolita. How these marketing codes are regulated? Under what authority? It belongs to whom? Whether we can issue a writ of mandamus?
So we consider disposal of this case receipt, we consider the case in accordance with law.
Oh, that is the second stage. Whether a writ is maintainable against them. What is this society? Is a society? It is a state instrumentality.
Under Assam State Regulation Marketing 1973.
Its
Yeah,
code is
control-
created by virtue of an act.
they
Okay.
are controlled by the
They are controlled by
agriculture.
They are independent agriculture.
Full stop. The petitioner who is an employee under Assam State Agricultural Marketing Board established in exercise of power under Section 3 of Assam Agricultural Produce Market Act 1970. It is the case of the petitioner that he was engaged as LDA on 11/7/2000 in the Karimganj District Regulated Marketing Committee, and by virtue of his seniority, he was entitled for promotion to the next higher cadre of marketing inspector under the Assam State Agricultural Marketing Board. However, according to the petitioner, ignoring his claim, two other LDAs were promoted to the post of marketing inspector on 3/1/2016. 3/1/2016.
30th,
Huh?
31,
31/2016, pursuant to an order passed by this court on 15/6/2007 in WPC 2921 of 2007. 2007. The order of promotion issued in favor of the other two LDAs is not under challenge, isn't it?
Yes.
The case of the petitioner is that still there is a vacancy of marketing inspector, and the case of the petitioner is required to be considered against the aforesaid.
So we consider him in his own catalog, LDA to UPA. Not in a
We are not saying that. And in the aforesaid backdrop, the learned counsel for the petitioner submits that the case of the petitioner may be directed to be considered for promotion in terms of service rule governing the field. Full stop. The learned counsel, Mr. N.J. Gogoi, representing the marketing board, has submitted that he will have no objection if the writ petition is disposed of for consideration of the case of the petitioner with a liberty to the employer to exercise to consider the case of the petitioner in terms of the rules governing the field. You are for? Who is option number 1? Full stop. MS G. Bora, learned counsel representing the agricultural department, has also expressed her no objection. Full stop. In view of the consensus at the bar, this present writ petition stands disposed of, directing the respondent number 2 to consider the case of the petitioner for promotion to the next higher grade as per the extent norm, and if he is within the zone of consideration. As per the extent, if he is within the zone of consideration, as per extent. Accordingly, the present writ petition, the petitioner shall be at liberty to file a fresh representation before the respondent number 2 within a period of 3 weeks from 1 month from the date of within a 1 month from today. In the event such an application is filed before the respondent number 2, same may be considered in terms of the court, in terms of the order passed herein above within a period of 4 weeks hereafter. The determination may be intimated to the petitioner. Yes, madam. None appeared for the petitioner on call.
Any applicants here in the.
None did represent the petitioner on 24/8/2022. What was it? None appeared for the petitioner on call. However, MSP Bora, Learned Standing Council for the Health Department is present. Full stop. None did represent the petitioner on 24/8/2022 and on 4/10/2022. Full stop. Accordingly, the present petitions are dismissed for none. Mr. Portico T. Bora and K.S. Hajalika for respondent number. Yes, Mr. Talia, what is this?
Sachip, I'm appearing for the,
Huh?
Sachip, here we have to file our impeachment petition. So last occasion we
Then
had,
why you are not here?
Sachip, I was actually on leg with different bodies.
Send somebody. How do you know that you are on leg?
I could make it, but otherwise I always
No, you'll have to say somebody. Everybody is there that he is on leg.
apologize.
Better.
I'll file my impeachment.
Mr. H. Alia, Learned Counsel
Open.
for the petitioner, praise for and is granted. 4 weeks time to file necessary application for impeachment.
Pay Fukan,
Okay, Puka.
DPF.
Be careful.
Right.
Matter of the records being called for, but from the communication
What is
That-
this?
I received,
You are for?
I'm to the High Court method.
Okay.
The records are with the registry method.
Okay.
I have not received them yet.
Why not? Why they are not giving
Because
you?
it was sent in 2017
Ah.
when I wrote for the records, but I received a set of communication. It transpires that the record is with the Joint Registrar Judicial.
Oh, that case.
Yes, but
That case. Hmm.
marks being accorded. It is with the Joint Registrar Judicial.
Okay. Uh, when will you fix it? When will you fix it?
Malad, subject to the convenience of the Honorable Court. And also, Malad, directed to Joint Registrar.
I'll obtain it after 15th of
Okay. Where is the order for record?
The last order, Malad,
Okay. This court
11,
under
12.
this order dated 11/12/2023. Asked the learned standing counsel, M.S. Sharma, and learned standing counsel for Guwahati High Court, M.S. Sharma, to keep ready the record relating to the impugned election process. Ms. Sharma submits that he has not yet received the record to some and the records are
With the
in
Joint
the,
Registrar
the
Judicial.
records are in the custody of Joint Register
Judicial.
Judicial. Accordingly, she prays for a turn. Prayer says aloud, please this matter on, they are proposing immediate
After the
after 15th
15th.
of March. Mr. Das,
Fine.
give a date,
19, Malad, of
18.
March.
18th,
Malad,
18th of March, full stop. The register judicial, Joint Register
Joint
Judicial
Register.
shall hand over the record to M.S. Sharma, Learned Standing Counsel for perusal of this court on the next day. Full
Like
stop.
record.
Yes.
Joint Registrar record.
meet the
Yes, somebody thought adjournment or what, something like that.
My lord, in this matter, the last occasion, lordship put a query on me, my lord.
We have already disposed of similar cases.
Yes.
That this relates to which permit?
What is
My
the sugar?
Assam Cooperative Sugar Mill Limited.
So what to do?
My lord, earlier,
In
Some-
that case, liquidation is still going on. Here,
Here it's over in
it-
2010 itself.
10 itself.
my lord, liquidator is still there, my lord, office of the liquidator is still there.
Can now claim be made statutorily?
Yes, my lord, the liquidator, my lord, liquidator is appointed under
Cooperative
section
Societies
66
Act.
Cooperative Societies Act.
Mm.
And the direct control of the register of the cooperative society. In that sense, my lord,
With a liberty to approach the competent authority, including the liquidator, is if the liquidator is still.
my lord, in this regard, my lord, the act itself has barred the civil court jurisdiction. As the circumstances are extraordinary, as to exercise extraordinary power, my lord.
No, okay, there is no problem on that. How will you determine
My lord,
that this you are entitled for this?
my lord,
This is filed by how many petitioners? One.
my lord.
Otherwise, we have been paid the dues, your lordship, 15 lakhs, around 50 lakhs to basic.
So that we understand. Their case is that that is wrong calculation.
Yes.
Who will determine in that case?
My lord, my case that not the wrong calculation. That calculation based on a wrong basis, my lord. The basis is determined by the government, my lord, not by the liquidator, not by the CA, my lord. My lord, the scale and to what extent they
Okay,
get.
suppose we agree your contention
Yes,
that your basis ought to have been X, but it has been treated to be Y.
Y.
We hold that.
yes, my lord.
Now, who will do this exercise when if the liquidation is over? Who will do this?
My lord,
Can we, by a writ of mandamus, ask to have a liquidation reopened?
my lord,
This matter, if you want to insist on, you argue it, will just go through the matter.
my lord, on this basis,
Before that, you satisfy us on the basis of the Cooperative Societies Act and others that in case of this kind of dispute, where liquidator has determined your entitlement on a wrong basis, assuming for a moment, the remedy is writ. Tell us that.
my lord, in this regard, my lord, can you allow me to file written argument, my lord, 2 or 3 days, my lord? I will
Okay.
file written argument.
Okay, learned counsel for the petitioner seeks further time to address this court in terms of this court order dated 7/2/2024. Please this matter on February 2017. We'll try it, no problem. 28th of February.
My lord, can you summarize it on 20?
Court of
Oblige,
Yeah, address that. If we can suppose whether it was basis was correct or wrong, that will come on later on. First, say us assuming that there is a mistake by liquidator. What is your remedy?
yes, sir.
If this court is having is the appropriate court, even to go to this disputed question, then we'll proceed.
Yes.
Then we'll go into the merit. But
Yes,
you'll have to satisfy first as the first part.
yes, sir.
Okay.
That is
If
correct.
you can satisfy, we'll proceed for the unmade.
I am starting that, my lord, direct.
No,
Similar
not
case I have
direct. You
not
can
filed.
show us that you don't have a civil court is part. Then what is the remedy against liquidity? Decision cannot be absolute. There must be some remedy. Where is that remedy?
That's why my lord can say.
Let us see. You cannot be remediless. That principle we know.
Yes.
But to what extent it is reached? More
Oblige,
to when there is a dispute. If you say that no, there is no question of calculation, but it's a question of principle.
yes, sir.
Principle A ought to have been applied. If you can satisfy that principle A, suppose we hold that yes, principle ought to have been applied.
Yes, my
Now
lord.
who will execute? How our order will be executed? That part we want to know first
Yes.
assured. We will not pass futile writ,
Definitely.
not issue futile writ. That is clear.
Yes,
yes.
sir. Oblige, my lord.
Please. Yes.
But if the matter is for non-payment of area as well as current salary.
Hmm.
First of all, you have to kindly come to the order dated 26/2/2020. Thereafter, matter was not listed. After fulfilling all the criteria and followed by the approval from the
Yes,
council,
where is the affidavit?
I was promoted.
After a long game, mother, it was listed.
No, it was why after longest period, it was
It
listed.
has not
We'll,
been
we'll,
listed.
we'll, and we'll make an inquiry
But-
because it was a fixed date, 27/3/2020. That part leave us, because we'll ask to register, have an inquiry, even after when the matter is fixed for personnel affairs, that was fixed, why it was not listed. And to fix responsibility upon the officers, we'll take care of that. Now tell us,
Give me Malad, only 2 weeks time. Malad.
at 2,
No, Malad, 2 weeks. Malad.
at 2.
No, otherwise, Malad, last communication, Malad, 20, Malad. Our
Last
service was-
communication?
Service was Malad regular. Last communication is
No,
dated, Malad.
service was regular is not an issue. Issue is payment of salary.
No, 2 weeks, Malad. I will.
No 2 weeks,
Malad,
no 2 weeks.
yesterday, Malad, vote taking was going on, Malad.
We
Yesterday
are,
only, Malad.
read court cannot stop for vote taking. Please don't say all this.
No, no, Malad.
This should not be your
No.
submission.
No, officers.
Should we shut down our courts
No,
for
no,
vote taking?
No, no, sorry, Malad. Officers are busy, Malad.
Let them be busy. These are also important votes. This is a right of a citizen.
Only two.
Their first
I-
responsibility is to just,
Only Malad.
if they are not entitled, say not entitled.
No, they are entitled, Malad. They are entitled, definitely, Malad.
If
These
they
are
are
communications,
entitled,
Malad.
if they are
These
entitled,
are communication on last Malad 20.
so therefore give us to that. We'll say that even after communication,
They have approved Malad higher service.
but don't say
Isn't
that
that-
somebody is busy in swearing it. Don't say that. Swearing in why? Because of the people elected you. Isn't it?
No, Malad, officers are busy, Malad.
That's why officers are busy for whom? For the persons who are elected by the people. So they will have the time for the citizens also.
Only 2 weeks, Malad. I will definitely, Malad.
Don't
Thank
make
you.
this kind of submission.
Sorry, Malad. Extremely sorry, Malad. He's entitled, Malad. See, her service was approved by the council.
Mr. Hanikal Lanet,
With effect from 30.
council appearing for the Dima Hasab, isn't it?
And NC is autonomous. Council.
NC Hills Autonomous Council submits that pursuant to this court's order dated 26/2/2020, comma, the promotion of the petitioner as what? Supervisor.
Supervisor.
As supervisor under Deung Valley ICDS project has already been approved. Has already been approved. This court, under its order dated 26/2/2020, directed that affidavit in opposition be filed within a period of 2 weeks from 26/2/2020, and in the event such affidavit is not filed, the Deputy Director, Social Welfare Department, Dima Hasab, or NC?
Now,
Yes, now NC is, Malad.
Okay.
For me, it was not a demand.
Dima Hasab,
District demand also.
the Social Welfare Department, NC Hills, District Dima Hasab, Haflong, was directed to personally remain present before this court on 27/3/2023. Though of date was fixed and a personal appearance was also directed in the event of non-filing of affidavit. However, this case was not listed on the date fixed by this court. Full stop. Who will enquire this? Register? When? Huh? Full stop. In view of the aforesaid, the registered judicial shall make an enquiry. Why? Even after specific order from this court for listing this matter on 27/3/2020, matter has not been listed since the February 2020 and has been listed in the after 4 years from passing of such order, and a report be submitted herein. Thereafter, this court will pass necessary order. No. Full stop. Place this matter on.
After which one ended it?
Give it. 7th of March.
Diploma.
Yes, madam. File an affidavit.
Okay.
If none appears for the petitioner on call. MSD Bora Learned Standing Counsel for the Health Department press for an is granted. 3 weeks time to file affidavit. In terms of this court's order dated till 31/1/2020, 4 years has gone by. These are
Mr.
sums given because
P.
we
Gogoi is appearing, he is on leave.
know that we understand.
Okay.
But health department, you cannot take that ground only be go. You have a set of lawyer. And one person cannot run around all the court. That we understand. But these cases are listed after long time.
Long time.
So therefore, we are a little bit lenient. But if next day no affidavit file will not be. Yes.
It is the promotion of the post of burden is a public promotion.
Promotion.
The post of burden matter. During the pendency of this matter, repetition, I have been promoted. My claim was that I should have been promoted in place of respondent number, private respondent matter, who is junior to me, and that process should have been filled up by the STH candidate matter.
Hmm.
Subsequently, I was promoted matter. Even then, matter that my issue regarding seniority and the post to fill up by matter.
No, tell us one thing. What is their stance regarding your seniority and entitled seniority vis-a-vis with the respondent number? Respondent number?
Private respondent matter, I think fourth.
What is their stance?
My lord, fourth. My
If
lord,
yes,
they
yes,
have
file
filed the
affidavit.
in their affidavit, my lord, that has been, they have not answered, my lord. Only the dispute is, my lord, whether I belong to STH or STP, my lord. That is the dispute for them, my lord. That have been, my lord, they have, my lord, categorically stated that I
What
have
is
been,
that?
but they have not, my lord, replied to my petition, my lord. Only that, my lord, issue, they have, my lord, tried to convince, my lord, that I belong to STP, not STH. Later on, they have promoted me as a STH. my lord.
What is the procedure of promotion and what is the eligibility criteria?
My lord, if I serve in the
Where
senior,
is that?
senior AA, my lord, then after five years, I'm entitled for promotion, me otherwise eligible. My lord. So,
Okay.
so accordingly, I've been promoted, my lord, from the junior administrative assistant
No, no,
Senior-
tell us when the promotion was made to the private sector.
in 2017.
Give us the date.
My lord,
Ready or not
Annexure
ready?
7, my lord, Annexure 7,
Tell us
8-5,
the date.
2017.
We will not see any annexure. Tell us the date.
8-5, 2017, my lord.
85
2017.
852017 respondent number
4
promoted.
promoted.
What is the procedure of promotion?
Procedure
DPC.
DPC.
DPC. What are the qualifications?
My lord, 5 years
Only 5 years.
experience in the under that post.
As per rule.
As per rule.
5 years
5 years, my lord.
experience.
Experience.
Any qualifications required?
My qualification that is graduate at the entry, my lord. Graduate.
5 years experience as
As senior AA, my lord, administrative assistant
senior administrative assistant.
to be promoted.
And the
to
post
superintendent.
is
Superintendent. The post of superintendent.
okay. When you entered into the service as
As my lord, LTA, but later on it is in my lord,
senior assistant.
junior assistant.
And when you become senior assistant,
2009, my
give us the date.
lord.
That is vital in a promotion.
My lord, my lord.
If you are not ready, tell us.
No, no, I'm ready, my lord. 9/6/2016, my
You were promoted to the feeder cadre on
lord. 31/9/20, my
31
30. That means January 2009.
January
2009, my
30th of January
30, my 30th of January.
30
My 30.
30
2009.
0109.
09.
And when the respondent was promoted to senior
Resident was promoted on 23 2009.
23/3/09.
2009.
Okay. Now 5 years will complete.
By my lord,
Okay. Now when the respondent was promoted to the next
my lord, on 8/5/2007.
8/5/17. When have you been promoted?
I have been promoted, my lord, 21/2/2018.
21
To 2018.
to 18. Now, what is their stand
Then
in the affidavit of not giving you promotion when your junior was promoted?
that has been not, my lord, they have said anything. They have not answered in that.
Yes.
So sir, in this case, also one service tool, minister service tool will be required. I'm asking my department to submit the service tool.
What is the service tool?
That service tool has given the specific duration and procedure of promotion. Matter was listed yesterday, Lordship. I have, by the time I was told that copy I received.
What is the service tool?
I don't know.
What it's called?
FP Assam Public Service Commission Ministerial Service.
In my file of getting, but there is a service rule, my lord. As per service rule, my lord, it is not disputed, my lord. Only thing is, my lord,
No, there might not be any dispute. As just deciding a promotion,
Right.
is it not required to go through the
my,
rule?
my lord, my lord. No, no. Only they are saying, my lord, when initially my entry was, my lord, this type
Lordship, can
plain.
it be taken up tomorrow, Lordship?
No.
Or at
We will
2 p.m.
take up it today.
At 2 p.m. Lordship.
No. This is not the way to do a case. We will do our job. From morning we are sitting, we are doing nothing.
So I apologize for my part. If Lordship give me at least 1 hour time, Lordship, I will address Lordship on time.
This is not
I'll try-
expected from beyond council like you.
I'll try to assist Lordship. At least
This is a promotion matter. He admitted this is the seniority rule, these are the dates. If there is no dispute, you will have to explain what is your stand in the affidavit.
My lord, don't have, but not that much.
What is your stand in the affidavit? That this is his case. Now, HP that will come later on,
Lordship.
is not it?
Page
If
52
only
is
the
a
seniority, why will you deprive him?
page 52 is a minute. Beyond that, I cannot go.
Page 52.
Page 52. Of my sorry, Lordship, of my affidavit in opposition. Lordship got it, superintendent record keeper.
Just a minute, just a minute.
52. আপনার yes.
Minus, where is the minus?
Lordship, page annexer 28 Lordship of my affidavit in opposition.
Sir,
28 Lordship, page 52, but it's my
page 52.
page 50. That last Lordship, is superintendent record keeper.
Where is the prescription regarding benchmark, fixing benchmark?
Lordship, in this affidavit, Lordship, it is filed, it was filed earlier of council Lordship. For taking handing over file, it just came for the first time. No,
Your book is also not having the relevant portion. Rule 4,
My lord,
which is vital. Merit comes seniority.
Right.
They say that your merit is not good.
my lord, they have said in the my lord, this minute also, my lord, see, they have said, my lord, they have not shown the name, my lord, who are within the junior consideration. They have to-
That is there. Why your name is not considered, that is also not there. Why not considered? You may
Either-
say you are, because others case you said benchmark is 16, okay, you may pick benchmark because it's a seniority, merit comes senior. Okay. Now, if if somebody crosses the benchmark, then you will have to go for the seniority. Not that above benchmark you will decide who has got more marks. Benchmark is there. That is the status of merit. If 5% crosses the benchmark, then the senior most you will have to consider. Why not? Nothing is there. Is it the way if you select your this own officers, what will you do for public employment?
Who are
And
16,
read
my
the constitution. What is written? What is the purpose of creating a public service by the constitution itself? If this is your standard, yes, Mr. Come prepared. This is not the way.
my lord, but to my extent, I have prepared my lord.
What you have prepared? The
My lord.
rule you are having not a copy of the rule. That
They
is the
don't have
vital.
also, my lord, that somehow have managed to get this copy of top. And only my lord, here is my contention is that he was promoted in the SC quota. So that post is therefore the STH, my lord. That is my contention.
Where is the question of quota? If you have reached the benchmark, you are senior. You will get somebody.
That is otherwise, my lord. That's
What
my
otherwise? That will get somebody else will get that
Right.
post. Why should we block
No.
it for you?
But
That
as
is
per
the principle of law.
Right.
So your vital case is that I am senior, I am having the benchmark.
my lord.
Why this STS, HCS business is here now? That is not necessary. Is it necessary?
No, my lord, they have India, they have said she has been promoted because in ST post there is a vacancy. That has been already occupied by someone. They could not fill up.
That will see. Vacancy was meant for as per roster only for the special drive. That is a different issue. If it is a general candidate, normal course of action, then you will have a right. But before that, you have already been promoted.
Right.
Now you want a claim of your junior being promoted. Now you will have to decide on that day whether you are entitled for promotion at all.
Right.
For that we need the qualification.
Right.
For
Right.
that we need the status of vacancy. 10 minutes this course can be decided if the answer comes quick. What is the date? What was the principle? What is the eligibility and how you have proceeded? Please this on the prayer of the learned council for the parties, please this matter up. Mata.
My lord, that, my lord. My lord, maybe on later also, my lord. Otherwise, my lord,
Give a date, give a date.
till 18 is pending, my lord.
Yes, what is this? Yes, Mr. Sharma.
Lordship, with regard to promotion of the petitioner, Lord, I have a letter received on 21 itself, Lordship, says Lordship, they are Lordship about to promote, Lord. Now I have telephone instruction is Lordship.
Every others are promoted, I think.
They have,
The high for the
I am told Lordship they are promoted, Lordship, but written instruction I have not received.
they have not got it.
Yes, Lord. They don't have that recommendation.
So have it at 2.
Lordship.
You have it. If you have promoted, we will not wait for it.
Lord.
Okay. Have a
Otherwise,
WhatsApp.
Lordship, written instruction is Lordship, sorry, oral instruction.
You
is
have
there,
oral instruction.
Lord.
Have a copy
Lord.
on the order of promotion. WhatsApp will keep it on recorded.
Lord.
The rest they will consider whether they are entitled for which date, what date. That will come.
Retrospective or not accepted.
Why should these matters be kept? Okay, Mr. Sharma, Sharma Lanet, counsel for the petitioner submission. He has instruction from his client not to praise this accordingly. Then the street petition says closed, not
I am clear.
not praised.
I am clear.
Mr. Sutia is
my lord, I taken undue advantage because I have a
Undue advantage will not
My-
give.
no, my lord.
If undue court cannot give. If
No,
you
no.
say this is, I want an due,
No, because my matter, another matter has been called, my lord. That is why I am submitting. My lord, I have one matter, item 44. My learned senior friend is appearing for the petitioner. We could not appear at the relevant time. My lord, the matter may be taken up immediately, or it may be taken up on Monday because I am
review,
not review. He's taking condonation. My lord.
condonation will continue, go home. That's all.
We have filed an
Then you wait,
we have filed an object.
you wait. How many days delay?
94 days delay.
That is a
Because-
foregone conclusion in this court.
Because I have filed the affidavit. My lord,
Okay, okay, take up this matter. We do not know about the fate of the review, but delay is controlled. Okay?
It is your lordship's discretion, but I have filed the objection. My lord.
Okay.
That may be recorded. At page 8, paragraph 5, I have submitted my affidavit in my
You do,
affidavit.
your
I have
affidavit
submitted.
is having no paragraph 8.
Page
It ends
8,
at paragraph 7.
no, my lord, page 8,
Page 8,
paragraph 5.
Huh?
Paragraph 5, because now the system is that the petition is to be tagged with the affidavit. So it is tagged with the affidavit.
I'm not getting it. You want to say page 8?
Eight.
Okay,
Page 8,
paragraph 5.
page 8, that is in my affidavit.
This matter, delay should doubly be controlled. There was a delay in uploading this on our part.
My lord, the answer is given in a paragraph 5 itself, because ultimately got the certified copy in the month of August.
Here was after, because we were in a little bit, we understand that matter, two brothers.
Yes.
Two brothers. Okay,
Rather.
two brothers. So there was a delay in uploading. Let us be fair. Generally, it does not happen, but it happened in this.
Sometimes
That is your
It happened.
friends, my lord, but only thing that
Third, 20, delay is explained at paragraph.
paragraph 4.
The respondent has filed an affidavit, and a specific stand has been taken that though stand that the counsel for the petitioner cannot that the stand of the review petitioner that the learned counsel was not aware of the judgment cannot be accepted, as the website has already shown on 14th day of August 2023 that RSA was disposed of. Full stop. The delay explained at paragraph 20 in the considered opinion of this court are sufficient reasons for which the review petition should not have been filed during the prescribed period of time. Accordingly, delay stands control. Registry released this review petition in the order column when tell us the date.
it alone. Yep.
12 March.
12 March, if
Except 7th March. 7th March.
12 March,
12.
March, subject to the condition that there is no defect in the review. Full stop. Registry also to show the name of MS and order. Highest and
My senior friend may be, learned friend may be directed to submit the copy. Review-
will not issue direction. He will give during the course of the. Yes, Musari. Of course, this is an undue bar.
No, I'm not well.
You are
That is
correct.
why.
This is an undue advantage.
I'm not well. That is why I made it.
Then it's a due.
I'm with.
Maybe. This is a case, madam, where ad hoc has been replaced by another set of ad hoc.
Ad hoc replaced by another set of ad hoc. Why?
They will know better than something, my lord.
What is their stand?
But their stand is that my performance is not good. But in this petition, my lord, there are 9 numbers of petitioners. Out of that, my lord, petitioner number 7, Rahul Nath, he has not been appointed. Rest has been appointed. But their affidavit, there are 7, my lord. They have not filed a detailed affidavit, my lord.
Any stay order? Initial?
Initially, there was, madam.
Then?
After that, madam, we approached the authority, madam. They have considered all the petitioners except this petitioner number 7. He has not been appointed. Rahul Nath.
So you made for pursuant to the new advertisement, all applied.
All applied, madam. All have been appointed.
Ah.
Except petitioner number 7.
Petitioner number
7.
7. Why his case was rejected?
They have stated in their affidavit, madam, para 7, page 76, that his performance was not good.
Then what to do? That decision is not under challenge. We cannot. What was the procedure? Written or only oral?
Oral.
Then how can we say that until and unless that is challenged, we certify the record?
They have not filed the still affidavit.
Huh?
They have not filed their still affidavit during the 30th of March.
No, even a file, can we decide? If you're in terms of the interim order, your cases were considered, this meter has become infraction on that we are giving you a liberty till today. We'll close it. The petitioners were engaged as district engineer consultant. Heard Mr. Spencer, learned counsel for the petitioner, and Spencer for the record. The petitioner were engaged as district engineer consultant. Dash Fisheries on 29/12/2016. After a due selection process under Assam Agricultural Competitiveness Project, within bracket AACP, full stop, on the on contractual basis. Though initially they were engaged for 1 year, their service continued until 31/3/2015. Thereafter, their services were terminated due to closure of the aforesaid scheme, within bracket AACP, উপরে যেটা ছিল Assam Agricultural Competitive Project, AACP. Full stop.
Yep.
Okay. Thereafter,
But they were absent in the year 2006.
2006, that's what I say. No, 29/12/2006. Isn't it?
Problem.
Thereafter, regular selection of junior engineer within bracket civil under the fishery department was undertaken by Assam Public Service Commission, and the petitioner, as former employees, has also offered their candidate. Full stop. However, they failed to qualify and their names did not appear in the select list, which was published on 17/10/2017 by Assam Public Service Commission. Thereafter, the Director of Fisheries had issued another advertisement notice on 31/3/2018 proposing to hire 15 engineering consultant dash fishery. The petitioners having the required qualification and experience were also interested to apply, but for the reason of upper age limit of 45 years as on 1/1/2018, the petitioner number 1, 2, 8, and 9 had become ineligible to offer their candidates. And the other respondents, other petitioners, though were qualified, however, their case is that they ought to have been allowed to be continued in those posts instead of replacing them by another ad hoc set of employees. In as much as it is their case that they have served for 9 long years as district engineering consultant fisheries. This court, while issuing notice under its interim order dated 9/4/2018, granted liberty to the petitioner to apply for the post of engineering consultant fishery. This court further directed that the candidature of the petitioners must receive consideration on merit along with other applicants. It was also provided that the petitioners number 1, 2, 8, and 9, the overage candidate should be allowed to participate, and their application should not be rejected on the ground of crossing upper age limit of 45 years. Subsequent to this, all the petitioners were selected and appointed to the post of engineering consultant as fisheries pursuant to the selection process initiated pursuant to advertisement dated 17/10/2017. Is that it?
Next up, 14 मतलब page 72,
17/10/2017.
मतलब 84/2018,
No. Page
72. Next up, 14.
page 70.
Last page.
हाँ 17/10.
Just publish.
हाँ
Just publish.
हाँ publication. That is what we want. Notice dated 17/10. You have written it 17/10/2017. Is that it? Top. Huh? Notice published on 17/10/2017. Okay. Notice dated at that. Notice published on 17. Or advertisement published on. Okay. The respondent number.
Petition number 7.
Petitioner number 7 was not selected. The respondent state who has filed the affidavit? APSC.
The director.
The
number
respondent number 2 has filed an affidavit and has taken a specific stand that the respondent number 7 was not appointed as he did not perform well in the interview.
Page 76.
Page 76.
Para 7.
Para
7 part.
7. Did not syllabus, comma. In view of the aforesaid, in the considered opinion of this court, nothing survives to be adjudicated in the present writ petition. Nothing survives to be adjudicated in the present writ petition. Full stop. The respondent number 7, the petitioner number 7, if aggrieved by his non-selection, shall have his independent right to assail such such determination of the selection committee if permissible under law. In view of the aforesaid, the writ petition can dispose of being infractuous, clause being infractuous, with the liberty of the respondent number 7 to approach the appropriate forum in the event he is aggrieved by his non-selection to the post of Porotitutilu.
Okay.
Third, Mr. B.D. Das, learned counsel for
Is contradiction. If they advertise, it's considered.
that is their third, Mr. B.D. Das, learned senior counsel, assistant at the P. Choudhury, learned counsel. The petitioner is two petitioners. The two petitioners earlier participated in a selection process to the post of senior assistant under the Directorate of PNRD BTC Kokrajhar pursuant to an walk-in interview pursuant to a notification of selection dated 24th of January 2014 for an walk-in interview. When the petitioners were not selected to the aforesaid court, they approached this court by filing a writ petition being WPC 1001/2015 and WPC 5976 of 2000. What was the name of these two petitioners?
One is called Himani Vasumotari.
Himani, na? Just a minute. Approach this court by filing WPC 6242/2015, petitioner number 1, and other one is
Ashok Kumar Dutta.
where is his name? Himani we got. Okay. By filing a writ petition, both jointly. By filing a writ petition being WPC 6242 of 2015. This court, while deciding the aforesaid writ petition, passed an order granting a liberty to the BTC authority to issue appropriate appointment orders to the petitioner to the petitioner. We were supposed to commit a huge mistake on the last occasion. Mr. Das, kindly see. Huh?
No, but I should say.
No, yes, me too, he too, everybody.
It happens.
Yes, it happens, but it's good that I have not, yes, dictation to come. See, Mr. Das, another problem here.
Regular.
No, you will come to the page 48. Is your whole basis.
Page 40.
Page 48.
Last one.
In view of the submission of the councils of the parties and in view of the withdrawal of WPC 5976/2015, the BTC authorities are at liberty to issue appropriate appointment orders to the petitioners in the above three writ petitioners at the earliest. Okay, as the three writ petitioners, namely and the three writ petitions, namely WPC 2022 have become infructuous. They are disposed of as infructuous.
Why it has become infructuous?
We do not know, but this is a judicial order.
Subsequently, they pass.
Okay. In the by the aforesaid judgment, as many as 1, 2, 3, 4, as many as 4 writ petitions were okay. Hold on. A statement was made this as many as 6 writ petitions, namely WPC 1001/2015, WPC 6242/2015, and WPC 7359/2015, and WPC 5976/2014. The order, the common order dated 25/5/2016 reflect that a statement was made by the petitioners council in WPC 1001/2015, WPC 6242/2015, and WPC number 7359/2015 that due to pendency of WPC 5976/2014, the appointment orders could not be issued to the respondent authority. Full stop. Because a submission was further made that as the WPC number 5976/2014 has in the meantime withdrawn, there is no impediment for the respondent authorities to issue appointment orders to the petitioner of writ petition 1001/6242 and 7359/2015. In the aforesaid backdrop, this court closed all the aforesaid writ petition with a liberty to issue appropriate appointment orders in respect of the petitioners in the three aforesaid three writ petitions, and accordingly the writ petitions were closed, being infructuous. This is the actual story. Subsequently, by an order dated 17th of July 2017, the BTC authority refused to issue appointments to the petitioners in WPC 6242 of 2015, that is the present petition, being agreed the present writ petition. The basic ground of refusal to such appointment by the respondent BTC that there were glaring mistakes in the advertisement dated 2022 as regards advertisement dated advertisement dated 24th of January 2014. So far, the same relates to filling up a post of senior assistant under the director of PNRD BTC and committee in as much as on the ground that they want to go for a fresh selection. Full stop. It was the case of the BTC that advertisement, there was a glaring mistake in the advertisement so far relating to the education, qualification and experience to the effect that the the post was to be filled, post of senior assistant was to be filled up, and an experience of 10 years as an 10 years experience, working experience as senior assistant under BTC was sought for, and the same was a mistake. In fact, that ought to have been a junior assistant. The further case of the BTC as reflected in the impugned order is that that will where we are coming to that. No, there's still a twist. So far relating to the post of UDA, the reason for cancelling the selection process and going for fresh selection was that the advertisement has prescribed for experience. That the advertisement so far relating to the filling up of post of UDA, the advertisement has prescribed for 10 years working experience as junior assistant / LDA in any establishment of government and semi-government officers. However, experience in government officers are only the requirement.
For PNR,
Not PNRD, UDA, because PNRD cannot be. Your one candidate was UDA. PNRD only was one vacancy. Someone is for UDA. That's why you argued the UDA. One is senior assistant, other is UDA. And accordingly, it was decided that the fresh selection process will be carried out. The aforesaid order is under challenge. It is seen from the record that the selection was on the basis of an walk-in interview, and the competent authority / employer has decided to go for a fresh selection with and changing the essential qualification. It is well settled that inclusion in the name in a select list shall not confer any indefeasible right or appointment, appointment, and the employer state can very well withdraw such selection process for sufficient reason. In the present case, the reasons shown in the considered opinion of this court are sufficient in as much as the government is within its jurisdiction to have the best possible worker by modifying the experience in as much as the reasons shown in the considered opinion can be a valid ground for cancellation of the petition. In the aforesaid backdrop, this court finds no merit in this petition. Accordingly, the sentence. But-
If they are
Okay, okay. If under the fresh selection, petitioner still wants to participate, the the competent authority of the PTC may consider relaxation of their age in terms of extent. What kind of instruction?
Whereas
Huh?
some of the petitioners
Hmm.
express the willingness of they're waiting for some of them. 2 weeks time may be given.
Learned counsel for the petitioner submits that he may be granted 10 days time to obtain instruction whether his clients are still interested in pursuing a present petition, in as much as the selection relates the selection under challenge relates back to the year 2016, whether private respondents are there. And
Before the
in the meantime, certain persons has already been appointed pursuant to such selection, and those persons are not arrayed as respondent, nor their selection has been challenged in the present. It should close it.
we have sought for the RTI regarding the cutoff. Right? We have not.
We have
That is a
up to
different
date,
issue.
we have up to date in the website, Lordship.
No, we think instruction. In all likelihood,
See, only thing is that you will have to come to the court once again only to say that this has become it. Or otherwise we'll close it on the ground that you have not made the other selected candidates respond. Is that it? So it's only a ventilation. And for that ventilation, many doctors and nurses are to work. Okay? That is an wastage of judicial time. Yes.
This relates to the non-payment of the salary. In item number 20, they have not filed the appeal.
What is your job and why they have not paid?
The lordship are working in group grade 3
Grade
Now-
3 where?
under the health department.
Yes, health. Why are you not paying? Mr. Gogoi.
If you found to be illegal, I have put a paragraph and I will file.
Okay.
The other two cases, the bidding.
Indeed.
Only
In
item
other
number
case,
20,
what is your stand?
Sir,
They have
take
terminated
upon-
her. That's the. this
take
case-
upon this, my lord. In fact, my lord, in a coordinate bench, my lord, these terminations have been upheld. Same procedure, madam. He is appearing for the appellant. It are now pending.
Close it.
Your lordship in
So let us wait till the division bench.
no. I want to close the matter, but there is a submission. Let it make the full submission. The issue is like this. The court has categorically observed that if they have paid their salary for the work they have done, that shouldn't be recovered. So if you have terminated me without doing a so-called personal hearing, then that is liable to be settled. However, I'm challenging only the non-payment of the salary. So for the period of work, they should pay.
That's
If
why
they're
I'm not
relying on
saying
that
that it
judgment,
should be
then that
closed, my
covers
lord.
it.
Lord, we will take up all three matters. Let me file the last appeal.
Okay.
Let
Mr.
it come
Gogoi
on Thursday.
submits that he has received a parawise
No, these
instruction,
three.
Huh?
Two weeks.
received parawise comments, and he would like to file an affidavit within a period of 2 days.
Fine.
He will be able to file an affidavit, not like, you will be able to file an affidavit in a period of 2 weeks. Accordingly, press for an adjournment. There are stands allowed, list on.
Your lordship, 21 and 22, it can be taken up next week. I'll place that.
All three may be taken up.
So, prepare.
Give it 11th of March. Gogoi, file
Well,
an affidavit.
Yes, sir. Obliged.
Yes, that's the mark. What is this?
is the record holder.
You are working as what? What is the grievance
Pioneer.
here? What is your grievance?
But it actually I
Okay.
yes it's the part there. That that so here it is initial
Now whether you have cut your hair or still there.
time technique. The my record.
So you want a writ of mandamus? Writ of mandamus asking them to allow you to grow your hair. This is one prayer. And what is your second?
I the number the here I the output the yeah.
Anything survive on that?
Is the
Practicing is what?
what effort just not the in it party new board
Okay.
the but my hair
No, whether you have, is there any interim order?
No.
If there is no interim, any action taken, you got your hair cut or what happened?
uh
You got your hair cut.
No.
They have not taken any action.
no that
What do you do? What is your
pioneer
job? Huh?
pioneer
Uh-huh.
I am pioneer
Pioneer, what pioneer?
uh I have labor work with the
Is a permanent employer.
Lordship, part of the year, Ms. S. Porwa, Simantani Porwa is on section 17, your Lordship. She has asked me to pass over the matter for the time being. Before the matter goes any further, that's why.
Okay, no, I have
The
got a
matter is
first case
interesting,
that
otherwise, your Lordship, the matter is interesting, but
matter is it
right to grow your hair.
yes so far except yeah
Uh.
but the part not
No, just let us tell you are a pioneer. What is the job profile of a pioneer?
pioneer part of the RTO
Is a permanent substantive post. Okay, what is your job profile?
the engineer concept the post
Okay. So, okay, fine. You are doing. What is the grievance that they are not allowing you to grow your hair as per their, you will have to get your hair cut as per the army's discipline. That option is yours. If there is a code, you will have to follow it, or you'll have to get your hair cut, or you'll have to come out to do your record, a Guinness record. This is one part. What is the second part from transfer?
I have 5 bill
Already.
already but I have third 5
Okay. Now where are you being posted?
transport
There is not a hill station. That part is also gone. So only what about your hair? Here we cannot say. What is your right to grow your hair in a disciplined court? Then there will be, because your right, all these private right are subject to reasonable restriction. If you file a writ petition tomorrow, okay, forget about Bar Council Act. I will not wear this coat and gown. This is a British era. I will not accept it. Allow me to have a tie or something different. You can erase either dhoti and paguri in your head.
adult but
That is a sport. Growing hair is not a sport.
I hear madam I am did the record I my how madam I am pulling a car truck by my
Pull the truck. Why you need to be in army? You are so powerful.
but that is where I am
We are not here to decide all this.
Yes, sir.
Yes, what is your stand? Tell us, where is your where is your guideline that nobody can have long hair beyond this? Tell us that.
In our affidavit, page number 11.
Yes.
11.
That's why, Mr. Sharma, you had your beautiful smile while standing. Page
11 of our affidavit.
What is this?
Point number 665.
No, no, what is this 665?
CSR.
Huh?
Guidelines for service group.
Okay. 665.
Non-sick personnel, the hair of the head will be kept short. The skin and the underlip will be same. And petitioner is not sick person.
Dismissal or withdrawal? Then we will dismiss it. This ventilation is over. Heard, Mr. Sharma, learned counsel for the petitioner, also heard.
Yes.
S. Borua, learned CGSC. The petitioner has been working as pioneer under Seema Sarak Bal. Isn't it? Under Seema Sarak Bal. At the time of filing this petition, he was posted under commandant where 1647 PNR file number respondent number 3. Isn't it? The grievance of the petitioner is that the grievance of the petitioner are of twofold. Firstly, the petitioner has already served different hill stations, and therefore he should be posted in a non-hill station, and his transfer shall be made in terms of existing transfer policy. The second grievance of the petitioner is that the petitioner wants to keep his hair long. However, the respondent are not, his employer are not allowing him to do. It is the case of the petitioner that to make a Guinness World Book record, he wants to grow his hair and such, if the petitioner achieves such an record, the same will help. His sale will also be a laurel to his employer. However, ignoring such fact, the petitioner is not being allowed to grow his hair long, in as much as some of the religious communities like Sikhs are allowed to grow their hair. The respondent employer has filed an affidavit and has taken a specific stand that the transfer of the petitioner has been made in terms of existing policy, and they will not make any transfer. They make the transfer in terms of their transfer policy only. And in the meantime, the petitioner has been posted in a non-hilly station at Bihar. It is a further submission of MS Borua that being a responsible employer, the Seema Sarak Bal shall always follows the transfer guideline to the extent possible, in as much as such guidelines are having only a guiding value and no indisputed right is conferred upon a person. Full stop. A further stand has been taken that the what is DSR?
Defense Service Regulation.
The chapter 14 of chapter 14 under part 3 of this defense service regulation, no, regulation 665 of defense service regulation prescribes that the hair of head of non-6 personnel be kept short, and therefore under such guideline, under such regulation, the respondent employer cannot allow the petitioner to grow hair as per his wish. That's all. Consider the argument that not very learned comes. Admittedly, the petitioner is an employee under discipline defense force which is involved in construction of border roads in India. There is also no dispute that the defense service regulation is applicable to the defense service regulation 665 clearly stipulates that non-6 personnel shall keep hair of head short. When the petitioner has entered into a service, his liberty to grow his hair shall always be subject to reasonable restriction of his service template. And therefore, he will not have any indefeasible right continuing with his service to grow hair beyond the prescribed limitation. That being the position, and without there being a right, this court cannot issue a writ of mandamus to the respondent authorities to allow the petitioner to grow his hair beyond the stipulation as prescribed under regulation 665. That being the position, the prayer of the petitioner so far relating to growing his hair long stands rejected. Coming to the transfer policy, as the petitioner has in the meantime been posted in a non-hilly station, and submission has been made that transfer are generally carried out in terms of the transfer guideline. This court, in the considered opinion, nothing survives to be adjudicated so far relating to the transfer of the petitioner, inasmuch as the petitioner shall always be at liberty if he to approach the competent authority or this court in the event is agreed by any order, and no omnibus order can be passed to the respondent. Accordingly, this petition stands dismissed.
Obliged. Matter relates to removal from service from SBI. The petitioner he has died, and his legal heirs have already been
Completed.
subsequent. Yes.
Okay.
So, now notice stating the merit.
Is for the bank?
Bank.
Any name shown?
Earlier, it court of
Are they representing?
yes, they
Good.
might reply
26. Where is the allegation?
page 28. The first if the enter was and but of the but expert day because he
You are Mr.
Teacher,
Mr. G.J. Sharma, learned, third Mr. G.J. Sharma, learned counsel for the petition. None appears for the respondent. The husband of the petitioner, who was a bank employee, was dismissed from service. It was removed from service of the bank after a departmental proceeding. Such decision was challenged by filing the present writ petition. Yes,
Okay, I will put number 2.
ready?
Okay, in this case, their main case is that the procedural, there were procedural lapses.
First tell us, are you ready?
No, no, the record is required in this case.
Okay, so produce the record we are carrying. None appears at that, Mr. Smith. Removed from service. During pendency of this writ petition, the removed bank employee expired. However, legal years got themselves substituted in this writ petition as in the event the prayer made in writ petition is allowed. Same will have a effect upon the entitlement of pension to the family. MS Burago High, learned counsel for the bank submits that as the basic challenge is based on procedural impropriety and failure of principles of natural justice, the relevant record shall be necessary. Accordingly, it submits that it may be granted
2 weeks time.
2 weeks time to obtain the record and to argue this matter. Prayer is allowed. Please this matter on. Will take some time. 14th of March 2024, on which date the record be kept available by the learned counsel.
Public.
Yes, Mr. Das.
Take care after subscribe.
Why?
Senior counsel, they want to append this next input number 1.
Okay. Okay. At two, almost 1 is 2 or we'll see. Yes, next. $29. Yes.
Mr. Peter, the petitioner has given retirement before superannuation. By complying the general principle, he has attained 68.
What is the general principle?
That appointment start from 18 years to 60. The petitioner was a minor at the time of temporary appointment.
Oh, that case.
Yes.
That is settled. We are of different view, but that's something. You have served more than 30 years or something like that. That's all. 42 years.
That is general principle. There is no law regarding that.
That is the law.
Yeah,
There must be some principle. You will enter at below 18 and you will continue. There must be a minimum. There is some law where minimum service is prescribed.
That is general principle is that 18 is eligible for appointment and 60 years retirement. That
So therefore, it is a principle. I made certain research because my view was a little bit different. I was in your favor initially. That okay, and that to a post of what you call it, cleaner, something like boy in a canteen.
Yes.
So in a country like India, though there is a bar, people are working everywhere as a child labor. Okay, now.
Retired benefits are
So if retail benefits are paid, what will you get? You will get only more period.
No,
Pension granted.
pension not granted.
pension you will apply, you will get.
Pension you grant. For the
Pension,
purpose of pension, will clarify it. For the purpose of pension,
No.
count his service and give it.
No, my instruction is, he did not submit the applications and all, let him submit it, there will be process. They are under a scheme, you know, pension scheme is different.
Okay, whatsoever, but don't count that period to deprive him from
No,
whatever is.
it's never.
For the
it's-
service, it's fine, but
No.
for the purpose of pension, that understanding will be different.
Pension,
If he has given the service,
no,
forget
pension is
about it.
not based on that. His last salary, 10 months, that will be calculated. That's the difference. This
okay, we'll hear after, we'll hear, are you ready today or what? File an application for
Yes,
pension.
I
They are-
can file an application considered. My instruction.
Petitioner has given the date because at that time, already that he is a minor. At the 75 to be paid.
Suppose we allow your repetition, what will happen today?
But he will continue till retirement. Then
What will be your retirement now?
by
When will you retire?
26 February.
We'll fix this matter on 2027. You have already served 42 years. They are willing to give you pension. I think they are fair. You cannot say that you will have whatever period you like. There are some law, isn't it? Okay, we'll hear it some other day. Let me,
I never decided. But
we'll,
yes,
we'll decide it.
decide-
We'll decide the principle. Okay,
decided.
give a date.
Next in March.
March,
No,
March.
my lord, today decide, but reserve for judgment. Because party has given, stays me.
Hmm?
Party has given, stays me. The dispose of it, whether I will get the benefit or not.
And he has got
But my lawyer
benefits
friend
he has got.
lingering the matter by giving the
Now there will be a lingering by the judge. If it is, if we go by your suggestion, if you make it CAB,
no, my lord.
so we want to decide here itself. Instead of keeping it for CAB and delivering after in the month of April, we'll decide on and dictate the order on 12th March. Which one is better?
My humble subject paper, lordship, as early as
Oh,
possible.
I should be on the first, I mean, after 14th of March, any day. Lordship may fix it.
What is the decision rendered in 2020-18 SCC 265?
That copy with the Lordship, the Supreme Court decision.
No, that is Supreme Court decision is different.
Finally, there was a conflicting judgment.
Therefore, what was determined in Gopal Prasad?
My lord, will have a idea in the last.
Gopal Prasad is there.
Yes, my lord. To three judgment copy will be there. Finally, the larger bench has
Heard in part, list this matter for further hearing on. Be ready, huh?
For that maybe.
18th of March. Yes, we'll decide this. There are divergent views, we'll take the appropriate according to us.
This view goes in favor of the petitioner. In favor of petitioner.
Supreme Court.
Supreme Court says, I will not enter into the decision of the High Court. High
No,
Court
no,
given the
therefore
benefit.
Supreme
High Court
Court
given
wa-
the
Supreme Court washed his hand. Now, both of the High Court's decision is not binding upon us. It's having only persuasive value. So which judgment pursues us? That is the clicking point. Isn't it?
The
two
independent
divergent
says,
views.
yes, I am against you. The other one says, so, I am in favor.
So you'll have to satisfy us Which view should we take?
RD.
That's all. Okay. Or we may have a different view also altogether. Mr. But there are some central government notifications.
Yes, Lordship is right.
There are certain central government notification and policies. So therefore, there will be three aspects, two judgments on different line. And other is the policy of the, whether that policy covered. That's all. There may be some reference in the, in fact, in the civil services. This also.
I'll come.
So we be prepared. We'll settle it. Yes, Mr. Sigdar.
My lord, I am item 31.
Hmm.
31.
30 and
My
30.
friend, Chaudhary item 30.
What are these?
Lord, issue is same, my lord. Same dispute, selection and appointment the grade 4 post under the district agriculture officer Golf.
Okay.
My lord, there was an advertisement, and following to that, initial selection. Lord, you will find the advertisement at
Just tell us, brief us the story. What?
my lord, advertisement, following the advertisement, there was an initial selection.
Hmm.
The list was forwarded to the director for recommendation.
Hmm.
The director says that the selection is required review.
Hmm.
And in that selection, the candidate with the item number 30 is in the top of the list. When it was again sent for review,
So first, there was a selection.
Yes.
Both of you participated. Now the selection committee recommends name of Madam Chaudhary's client.
Okay.
Now the director says that after going through the selection, says that no, this is
That will be
you want a review. Then it's reviewed. Then you were selected.
I am selected.
Now that what happened thereafter?
Then I was, my name was forwarded by the district officer. The director said that the earlier selection is not cancelled before selecting me. That was a wrong order, my lord. There was cancelled. My appointment, the earlier selection was cancelled.
Okay.
So
Now what is the basis of selecting her by the selection committee? We'll come back at 2. What is the basis of selection? And when was select list published?
my lord,
Huh?
my lord, after review, the selection was
No,
made on
when is the first selection?
25th March
25th March
25 3
2018. Okay. Then she was selected.
two candidates were selected. Rajasthan and Bonjit Kolita. Rajasthan is item 30. So both of them have secured the same mark.
Item 30 and who? Both.
And another one, they have secured
Not before. Item 30 was selected.
they have
Then-
secured the same mark.
Okay. Then what happened?
That's why the director wanted the review why Bonjit Kolita was not selected. Though he has secured the same mark as serial number 1.
Okay. Then
Then the review was conducted. Then item number 31, he was selected.
why?
And item number 30, Rajasthan, after the review, he scored 29
Review on the
second
basis
selection.
of what?
because in the first select list, both candidates secured the same marks and one
Now a
was
third has come.
What?
Isn't it? There were 2 got the same mark.
two got the same mark.
Same mark. Then director says, so 2 got same mark.
One
Who will be the one?
Yeah.
Who will be the
the
first?
second was overqualified. Lordship. That's why in the advertisement it was given one overqualified will not be selected.
Okay, so second is gone.
Yes.
So her client is there. Just let me understand. Her client is there.
Yes.
Now, hereafter, what is the basis of review and giving Mr. Sigdar's client?
That's why they reviewed the whole selection. They had gone
Okay,
through the
on the-
examination process.
On the basis of the marks obtained in the written examination and on the basis of interview mark, they reviewed it or they had a fresh selection.
Fresh select.
so
Fresh selection amongst those persons,
Yes.
including written.
1 to 20 of the earlier select list. From serial number 1 to 20, the candidates they had the press selection.
only those persons were called.
Yes.
Okay, then he got selected.
Then
Earlier it was 10, now it's
Anyway,
then
okay.
he got
Now,
now the select list
no.
lordship the
when the
validity
second select list was published,
because of that the board secured the
no,
same.
no, when the second was published, that's
Second was
second one.
published on 18/1/2021.
18/1/2021. Who challenged this
My
selection?
lord, my lord,
No one.
no one
No
has
one,
challenged
no
my
one.
select.
No, but
No one has. My lord, my friend's client is.
Now then, why are you before this board?
My lord, because I am not appointed.
nobody
Therefore,
is
I am.
appointed lordship because the
Therefore,
expiry
I am.
the select list is already expired lordship on 31/3/2020.
No.
SIU
No,
approved.
no, it will expire on, okay, SI will come later on.
Expire. It may expire after
When this
18/1/22.
petition was filed?
My lord, writ petition was filed on 26/3/2020.
20,
26/3.
so after 3 months of the select list.
Yes.
Second select list.
Yes.
So why it will expire?
The validity of the select list
It's 1 year.
1 year.
So he has approached this filed this writ petition within 1 year. Law is well settled. During pendency, it will not expire. It will stop. Suppose we decide after 3 years, can you say that no, it has expired in the meantime? Law is well settled on that regard. That's why I'm asking that dates are important. So that part is gone. Now, no third party has come, and you have also not specifically cancelled the second selection.
No.
He
Prima facie.
he has also claiming
Now,
as per earlier selection. my
so
lord.
therefore, we'll have to see, have you challenged the subsequent selection?
I have quite right. Not the second part.
We'll decide. Why should the government be deprived of an appointment at 2? No time. We have already deliberated. We could understand the method. That's all.
We couldn't appoint anyone because of the
Why should we deprive the department from a candidate? We'll see. If you have not challenged that, that's all. 50?
We made the communication, but not.
Let us try today itself. Have a telephonic. These methods should not be kept. Just have an instruction. I do not think anything survives in this.
Right.
Last occasion also he was not there. Today also not there. Just have a instruction. Whatever. Yes. Yes, Bothakur, what is this?
That's no proceeding authority of withholding
So
of
we have only how many meters left? We start at 2.
or your
Or you have some difficulty.
lordship if some of the
Because otherwise it will. We understand. Okay, Mr. Bothakur, we'll go into March. Respondent is granted. 6 for an adjournment. Vice Chancellor, please this matter on
14.
or 21st. 21st of March. Yes, Mr. Das, what is your case and all? Okay. Which are the matters? Please tell me. Which are left over? Item 1. Okay. Item 15. Item 27. Mr. Das, your one is 27. Then 35 and 50. Why 51? 51 is over.
you. I don't know that the
in the event petitioner shall agree by any of the decision passed on their representation, they shall be referred to approach the appropriate forum, including this.
All right, grateful.
Repetition. Yes, Mr. Moto.
My lord, regarding my lord,
What about 35 and 42? Let us complete this order. 35. Okay, wait. Yes, Mr. Are you going for final disposal?
Because matter has been adhered.
no, my lord, small point, my lord.
Yes.
There's a name, my lord, his name and my name similar. So his name, my lord, published in the list, my lord, selected list. After 1 hour, it is my lord, corrigendum stood, my lord, my name was published. That has been challenged before this honorable court. Now, my lord, your lordship kindly see his pair, my lord. So, my lord,
Who is the selecting authority?
no, now, my lord, this honorable court asked them to produce the, my lord, who is getting highest mark.
Yes.
That will be selected, my lord. So, that is his pair also. So, that's a record based before your lordship.
Okay, that is that.
Your lordship, that is their pair, my lord. They cannot go out from their pair, my lord. Your lordship kindly see page 8, my lord. Page 8, my lord.
This is a case of the where I have made allegations against the members of the selection committee. All the 4 members of the 3 members against the 3 members of the charge sheet has been filed. Instrument vigilance has
That is not been challenge made before this
Yes.
court, my lord. There is no, if there is allegation, that has to be made party, my lord. He is not challenging the entire, my lord, process, my lord.
Just give me a minute.
Your lordship kindly go by the pair, my lord.
Okay.
Page 8, my lord.
Nurul Islam Ahmed, isn't
Yes,
it?
lord. One is Nurul Islam Ahmed and other is, my lord, Nurul
What
Islam.
are these posts?
Gaumbura.
Dhamapura.
Gaumbura.
Dhamapura appointment, why read?
Of course, my lord, there is a earlier occasion, my lord. Is a provision for
although there is an alternative remedy available, lordship, during the last 6 months, lordship, the office of the divisional commissioner has been abolished. The deputy commissioner, lordship, is still involved in this corruption case. He has been implicated now, lordship, the government has sought lordship prosecution sanction against her. And the other 86 lordship, the 3 members, they have been suspended. They have been put behind the bars and they all have been arrested.
Oh,
They are
that
still under
is.
suspension. So, look, we have the appellate authority, look, the record should come from the DC office only. Look. So, in this petition, look, I have brought on record, look, the certificate file in respect of the case, indicating, look, the members of the state, and it has been proved. Whatever allegation I have made in my defense.
That is not their pleaded case, my lord. Your lordship kindly see the pleaded case, my lord. My lord, he is out of going his pleading, my lord. His, my lord, pair is that, my lord. Your lordship kindly see the pair.
What is the stand of the selection committee? Affidavit file? Respondent number 1. Who is respondent number 1?
Is the chairman, deputy commissioner.
Okay.
That's why the
Okay, do you have a selection?
Yes. The respondent got black mark out.
What is this? Borampur.
That's
12.
Simpara revenue.
What is the name of the respondent?
Nurul Islam. On an earlier occasion, Lordship, the respondent number 7 has produced the record on behalf of the government. And Lordship, this court, honorable court, detected Lordship that election record was which was produced by the respondent number 7 that feared only the signature of the deputy commissioner Atika Sultan. The other members did not sign. That is why Lordship, this honorable court, by further order, directed that.
What is your name?
My name is Lordship Nurul Islam.
And what is the name of the other person?
Nurul Islam Sheikh.
Sheikh. The last portion is my Ahmed and Sheikh. That is the
What is the name of your father?
Lordship, my father's name is Lordship Abdul Aziz, and his father's name is Gyan Bepar.
Yam Bepari.
Gogan Bepar.
Gogon Bepari. Where is his selection? Nurul Islam Sheikh.
So that next one are marks given by the committee. All other sector persons except this one. But
This is the comparative statement. Any proceeding of the selection committee?
it's a comparative.
It is the
it's a panel
comparative
lecture.
that this happened, therefore we have to change it, we'll have to issue the corrigendum corrector.
That is followed to that is some other root kit.
So give us that.
It will mistake of like this mistake. Like this.
You want the record, not that compared.
So regarding
There are note, office note for fixation of selection of modality of the because here he had a specific statement that when it was seen subsequently, it was by way of manipulation. That is his submission. This order sheet, let him see also. These are type copies signed by all the selection committee members. So apparently, we do not find anything on this record. But under what circumstances? Because this is the corrected, is not it? This is the corrected or something. There must be a reason. There must be selection proceeding. there is a modality fixed. The office note says the modality was fixed. How to be done, what to be done. So, and that has a reference of the page number. A minutes of meeting held on 3/6/18 for eligible candidates of so and so for its so and so is for approval. So that is vital.
Yes, my lord, that's the vital. My lord, problem is this, my lord, your lordship kindly see when, my lord, I file a application for vacating stay, and this honorable court says, yes, I will call for a mark, and then that's why the vacation list petition was not being heard, my lord. So I will finally dispose of. Problem,
Let us do it.
yes, my lord, why problem is this, my lord? I am.
No, I understand. Not only your, this is the anxiety of the government. Whosoever, your
My lord.
anxiety is that I got highest mark, I should be appointed. His anxiety is that the post is kept vacant. Why should a Gauburas post be kept vacant?
Even otherwise, my lord, after 1 year, I'll be retired if I appointed, because it is now is 65. Now already I am 64, my lord. So that is the problem. So if it is delayed, my lord, it will be.
When? Not why these officers are half-hearted? Huh? Because he had made a specific meetings in a paragraph. That's why I have seen that. What is his case? If he says that it was only a mistake or something like that. His case is that I was actually selected,
My lord.
but subsequently there was a manipulation. They got money and changed my name.
Yes.
So let us see what
His allegation.
let us see his allegation. Let us see what under what there must be minute. We cannot go
Yes,
beyond
exactly.
the minute. That's all. Isn't it, Mr. Das?
Yes.
Maybe we are not here the investigating authority.
In fact, Lordship, this honorable court has recorded the response number 7 has produced the selection
Seven?
record. Yes, response number
How
7
can
has
I
produced.
produce that?
Yes, Lordship, may kindly see page 185. That is
No, but today this has
Response
been
lost
produced by
page
Mr.
151. Yes, so that record was produced by Mr. Response 7. The Land Council for response number 7 has produced the interview sheet for selection of lot number 12. And Impara revenue on 26/10/2018. The same shows that the petitioner had taken 11 marks and
Oh.
response number 7 has taken
Yes.
12 marks. However, the
It was
interview sheet
his
bears the signature of the deputy commissioner. Subsequently, this honorable court has passed an order. Why appropriate orders should not be passed for interfering with the selection illegally made by the selection committee, which that resulted in charge sheet being filed against the committee members. Thereafter, Lordship, this honorable court has passed why so cause not be issued to the divisional commissioner for not interfering with the selection. Now, in the
My lord, I
meanwhile,
am submitting, my lord.
the divisional commissioner office has been abolished.
My lord, everything is by same vigilance in that case, my. So, although not related to this case, my. So we applied for a copy, then accordingly, with application and on application that result it was given to me. That's why probably he submitted. At that time, I'm not there, my lord. But he says that, my lord, he filed an application before Superintendent of Police Criminal CM Vigilance. I got the certified copy from there.
Now, what is the present state of affairs? Is there any allegation regarding this?
No, that is in respect of other my lord, as a whole, my lord, in that district, my lord, but others are all are appointed now, my lord.
Lordship, may kindly
All
see
are
the
appointed.
Lordship,
All are appointed, except this one, my lord.
all have been appointed except because these are individual cases.
Okay. Let this request be not further lingered. And Mr. Sutia.
Yes.
Monday? Who saw? 29.
My
We
My
have
lord,
understood the issues.
my lord,
Show him the
my lord.
record, Mr. Sutia. Let him have a satisfaction. You have the record because these are the Xerox and there are references. You just go through it.
I got put it. Lordship, this must be photocopy because the original has been prepared at the case.
Obviously, that has to be photocopy because until
Anyway, photocopy will not doubt it, but there are certain recommendations. Draft is prepared regarding the police verification of so. No, there are something. Where is that flag? Minutes of the meeting held on 31. Any minutes is here with. We want to know under what circumstances the
Yes.
decision was taken. That's all.
that's the fact of the matter
That's a crowd matter.
because his
If
name.
we have
his
any
name-
doubt, that is a different issue. But as a read court, we have our own limitation.
My lord. Why?
When a
Why?
criminal case is there, we cannot assume that we
In another petition, Lordship, the scan of the Department of Lordship appearing for the Lordship has been recorded. Lordship, they did not differ with the findings of the search. They did not
No,
equal with
no.
the findings of the search.
See,
That was
Mr. Das,
recorded.
two aspects of the matter. Suppose there is a search sheet. Prima facie, we say that yes, search sheet means prima facie things are found. Now, can you propagate a law because there is a search sheet and government thinks that they want to go ahead with the selection? Can a report say no, no, no? Your selection process is liable to be set aside only on the ground that there is a search. Can that be?
After filing of the search sheet, in fact, also the government has removed 4 of the Gaon products. They have now taken
Anything on record by
yes,
affidavit?
anything, yes, I have brought on record.
Okay, okay, we'll hear. 29th.
29.
You have list this matter on 29th. Mr. Sutia has produced the compilation sheet as regards grant of mark by the examiner. However, record pertaining to the decision of the selection committee to recall the name of the petitioner from the earlier select list by issuing a corrigendum and taking a decision to appoint the respondent number 7 is not available. Is not available. Accordingly, Mr. Sutia submits that he may be granted time till 29th of February to produce the note sheets and record, including the minutes of the selection committee, wherein a decision to issue the corrigendum was issued. A decision to issue the corrigendum was made. There is allowed. List accordingly.
So, interim order.
Interim order, partially shall continue till then.
Apply.
What is this?
My lord, matter related.
Oh, that case, that case.
Yes, sir. Look at some relevant documents. Next, sir.
No, let us see the decision of the.
Mile. Yes.
Let us see 3 decisions. Forget about others things. Others are not in dispute.
Mile.
Where is Madam Chaudhary? Will she be able to come? If not, then we will not proceed. We'll take it at some other day. Okay, all the other matters will wait for something. Wait for something. In her absence, we cannot proceed. Isn't it? Wait for some time. All the other matter will come back the 35. Yes. None appears for the petitioner on call. No. When the matter was called in the fourth freelance session, none represented the petition. Accordingly, matter was again taken up as the last item. However, when the matter is called again, none represents the petition. The Lavazima Court, under its order dated 5/10/2023, directed the petition to take press step for service of notice upon respondent number 6 to 8 by registered post with KD, as well as by usual court process. However, the petitioner has not taken any step till date. Accordingly, matter was again taken up by the Lajima Court on 1/2/2024 and 7 days time was granted to comply with the order of the Lajima Court dated 5/10/2023. However, no step has yet been taken as reflected in the office note dated 9/2/2024. Be that as it may, as none appeared for the petitioner at all, the petition none appeared to conduct a case for the repetition and dismiss for none. Ready? Ready?
I have not said the second.
Yes, Sigdar, let us understand you. Okay. Where is Madam?
Lordship has asked them seen the want to see the impugned order.
So we want to see the first selection.
First selection.
First selection.
First selection select this annex. It is that in her read petition. In my read petition, I have annexed my admit card and forwarding after selection.
Where is her case? Let's see what she is helping you.
My
Your is 1278. Page
page
page 60.
1/6.
One.
Merit list of candidate appearing rejected for the Andita held with target AM Rajasthan and that time Bob repeatedly that my name is that period.
Where page?
Well, page 1/6. Annexer.
Yes, tell us.
But in that selection, the repeat earlier item 30. Rajasthan is that serial number.
Where?
Serial
number?
Serial number 9.
Serial number?
Application number 9.
Application number 9.
Yes.
Raj Khan.
Raj Khan.
He got 48.
48.
Okay. Then Bonjit Kolita
Bonjit Kolita
got 48.
48.
Then what is
Mohidul Islam.
your name?
My name is at serial number 10.
Serial number?
Hedayatullah Khan. I
Not
got
serial number 10. Your
Yes.
name is applicant number 10.
applicant.
Hedayatullah Khan.
I got 44.
Okay, what happened thereafter?
My lord, thereafter, my lord, the selected this petition, there is no further ballot paper. After the selection, my lord, the annexer 4 in my petition.
Okay, so this is the select list.
Yes.
Then
Page 27 of my read.
page
27 of my
27.
annexer 4.
Yes.
My lord, so the letter issued by the district agriculture officer to the director.
Here, my lord, reference to the above, it needs stated that it connects the files of both of grade 4 and reserve. There seems to be 3 candidates in the merit list determined on the written test and Sarvasri Raj Khan, Vandit Kalsa, Mohit Islam, Abhishek Kumar.
Then what happened?
Then my lord, it was the letter issued, by the director to the
So
Agriculture
he
officer
was, the
to review.
selection committee was asked to recast.
Yes,
Recast.
sir.
Meaning whatever mark you have got, you give the reason why when there are 248, 146, there are two vacancies,
One
vacancy.
vacancy.
So you have chosen 148,
One
not the second 48. Why?
Right. So, my lord, it was direction for review the proposal and distribute the comment. Then, my lord, there was another letter, another 5, that this should be done within 31st March 2015.
Okay, forget about that. For
Yes,
now,
my-
what did he do?
Then, my lord, Annexer 6, my lord,
Hmm.
the committee, district selection committee, they have sit on 23rd November 2020, and they have taken resolution for review. My lord, script resolution, my lord, after threadbare discussion, the meeting arrived for following decision. The House suggested for final appointment to Sri Parkov Prabha for the post of grade 4 reserve. There is another post for reserve candidate with immediate effect. For that, the House requested to member secretary to submit all requirements to the district agriculture officer for completion of appointment process immediately with a copy to the director secretary.
Well, forget about that. That is not our concern.
Yes, well,
Come to serial number 2.
two
Hmm.
is well. The House also discussed thoroughly on the director's letter number so dated 18/12/2018 regarding the review of merit list for the period of grade 4 unreserved 1. Accordingly, after thorough discussion on director's letter, the committee cancelled the earlier selection
How can they?
against against the grade 4 unreserved only. In addition, the House decided to recheck 20 numbers of answer sheets from serial number 01 to 20 of the merit list on or before 15 December 2020. The committee earnestly requests.
Okay, fine. Now what happened thereafter?
Then, my lord, again they have
Okay, it was rechecked. Then
recheck, my lord. Then, my lord, annexer 7,
rechecked all the question papers.
my lord,
Okay,
1 to 20 candidates.
why 1 to 20? If 21 has done well, then so that is what I am asking. I wonder what circumstances. What is the stand of the government? You want to cancel this election?
What do you want to do?
Those
last
20% are on in the merit list.
Understand? 1 to 20 in the merit list.
Correct.
You re-examine the question paper.
Then
Answer sheet. Why not the 21st? If there is so much of variation, the 21 might have got 50. Where is the guarantee that 1 to 20 will have only better candidate? If there is a mistake, there is a mistake for everybody. If you can do a review and there is a huge sense upside down, why the 26 will? This is an absolute violation of Article 16. And who issued this advertisement? Under whose direction? House Election Committee can take such a decision? Will show to say, sir. Yes, madam, what is your stand?
Lordship, the last letter that they have issued on 23rd March 2021, that is the last 10 of the government in my affidavit, Lordship, the director has written to the district agricultural officer that you are therefore requested to take proper decision in the district selection committee, even to the extent of conducting re-examination amongst the selected candidates in respect of both the categories of district. This is the last. Let me
Yes,
take it.
Mr. Sikdar. You are before a court of equity. You are alleging violation of Article 14 and 16. What is the parameter? Good parameter that will have 1 to 20.
Well, there has been no specific direction that they cannot recheck the 120. They have decided that we will take 1 to 20
Why?
candidates.
What is the good reason? Every state action must have a reason supported by reason. Isn't it? See, even you are in a report, there are 30% or 50%. Everybody appeared in the exam. 2%, when first time there was an examination, 2% top, 48. Director says, there are 2% 48. Give us the reason why have you recommended one? There could have many options. There could have been tossed. That is also permissible by the Supreme Court. There may be question of who is older in age. Okay, you decide we will examine the answer script of the 20 candidates. Okay, fine. Up to that, it's fine. When you examine 1 to 20, the earlier 1, 2, 3 is nowhere.
No, that is not my.
Huh?
There in
No, listen to me. 1 to 20, there is a rank difference in ranking. There may be some other teacher. So there is a possibility that 21 gets 49. Can you rule out that? What is the good reason to select 20? This is violation of Article 14. Straight. This selection should go. And you are at liberty to go for a fresh selection.
But nobody has challenged.
Not necessary. We are in a writ court. If we can issue a direction, writ court hand can reach anywhere. Can we allow this kind of a petition? That no, he now appoint him. Forget about others. We'll have to say that. That since others has not challenged, so let the illegality continue. If you say that we can do that.
Lordship may call for the record, but entire record.
No. What is the necessity of record? The selection record
My lord,
itself says.
My lord, if the selection committee does not commit any mistake in comparing this merit list.
No, that is not the issue. You might have gotten maximum number. No problem. We are not doubting re-examination. We are not doubting re-examination. But we are thinking of a possibility. Why up to 20? 20 first may got more than you mark that you have got. There is a possibility. What is the fundamental question on the basis of reason, on the basis of which they have decided to do only 21? We would have accepted, okay, there will be a new re-examination between the both equal person. Fine. Okay.
There
You
has
have-
been you
have done-
statement.
Huh?
In the my lord, order of direction of the director that has not been specifically
No, they have not said. Director said
They have
you
said to
you
review.
review. You review. What can be possible ways of review? Because there are two equal positions. Is it a possible way that will exclude from 21 up to 20 will have a re-exam? If you have a re-scrutiny, have the re-scrutiny of all. If you want to have no, since already there is a scrutiny, only 2 persons are there, let there be an examination between second level of examination between these two. It's a public appointment. People are running for appointment. That could have been a reasonable thing. Okay. Others, you are out already, you are out. We cannot give you relief. But first two, you have a press examination or press interview or whatsoever. Because they are categorized in a one class. So that would have been a reasonable classification. Now, what is this classification from 1 to 20, excluding 21? If there is no reasonable classification, it hits at Article 14. And if it is Article 14, we cannot pass a direction for your appointment in violation of Article 14. They will have to liberty how they proceed, but this cannot. Because according to them, they have not accepted this course of action. This is the
my lord, anything may happen. There may be, my lord,
so if
in the
anything
first
may
election, there may be a illegality.
understand. So therefore, anything may happen. So your right is this is my right.
My lord,
Your right is based on what? What principle?
my lord, for the entire record of selection may be called for.
Not necessary. Admittedly, you have said that
My
you
lord,
have.
my grievance is against the order, impugn order dated 3/3/2021.
Show us where is that order?
My lord, Annexure 11,
Page.
page 38. Here it said that the earlier selection is not cancelled. So you have to go for a fresh re-examination. Page
Where
38.
is page?
Page 38 in my report. With reference to subject cited, response to your letter. Your reply was but your letter under reference to a name Siraj Khan, who was issued high court advocate, was recommended for approval for treatment against undeserved advocate post and work of Prabha specific advocate post. By the time validity of SI approval was required after issuance of extended validity of SI approval, to have proposed another name of candidate Hidayatullah Khan, who is shown to secure 47 marks, though originally he secured 46 marks, and in doing so, you have not cancelled the item. That was the earlier selection was not cancelled. On that ground, they directed take a fresh re-examination. But in fact, that list was cancelled in another 6. I have to prepare people that this entire case record, my lord, record may be called for. My lord, there may be anything. I was 46 earlier. Now, my lord, I am higher.
Understand, that is the
44.
difficulty.
I am 44 now.
What was your earlier number?
Earlier number was 46.
46. Now,
Now I am 44.
now you are 44. What happened to the 48? What is his score? What is his score? Who was 48? Who was number 1? What is his score now? Tell us.
My lord,
Huh?
they are also.
So he's 39. How do you know that? What was the rank
39.
mark of 21? Serial number 21? What is the number of
Since
21?
no one has challenged my selection, my lord.
We'll
Record
answer
may
that.
be-
Very
record
nice.
may be called for.
Very nicely we'll answer that.
40.
Huh?
Ultimate fault both the selection procedure. Prepare gross and
Why are you sitting? Why are you giving all this handle to the selection committee?
it is a
You are the authority. Decide, no, this is not the way. You cancel it, have a fresh selection.
yes, yes. You will have a section.
We record it.
Yes.
That I have instruction from
Yes,
the
yes.
client that they will go for a fresh.
Yes.
This is not the way, Mr. Sikar.
Well.
Heard Mr. A.R. Sikar, Learned Counsel for the Petition. In WPC 2417/2021. And MS R. Chaudhuri in WPC 1278 and MS Bora R. Bora for the Learned Counsel for the respondents. Hearing concluded, judgment written.
Develop.
This case, my lord, for telephone instruction, my lord, the
Huh?
provisional pension is getting.
Getting.
His
Uh,
care is limited.
None appears for the petitioner on call. None did represent the petitioner when the matter was called on 9/2/2024. In the aforesaid backdrop, this court requested Mr. Borazuli, requested Mr. D. Bora, Learned Counsel, for the Mr. Borazuli, Learned Counsel representing the respondents. No, then আগৰ অৰ্ডাৰটো আপুনি লিখিব ফাৰ্ষ্ট পেৰাগ্ৰাফ সেকেন্ড পেৰাগ্ৰাফ থাৰ্ড পেৰাগ্ৰাফ fourth paragraph. In the aforesaid backdrop, this court requested Mr. Parazuli to obtain instruction as regard the status of compliance of interim order dated 27/7/2018 and the status of departmental proceeding. Anything?
Different person is complete.
What happened?
Uh,
Exonerated.
no, my lord. I'm giving 2 black marks.
Okay. Okay. On instruction, Mr. Parazuli has submitted that pursuant to this court's order dated, interim order dated 27/7/2018, the petitioner has been paid provisional pension in as much as departmental proceeding was concluded with a penalty of imposition of 2 black marks. Be that as it may, as none appears for the petitioner and the interim order has been stated to have been complied with, the writ petition stands dismissed for non-proceeding. If they want to come, let them. That's all.